This morning with the great Tim Takacs. Appreciate him coming on. Elder care attorney joining us from his office there in, Hendersonville, correct?
Right, in Hendersonville.
Are you the only one there right now?
I am actually in my office downstairs in my house.
Oh, okay. Well, you are the only one there then.
It's exactly. Except for one of the 5 cats, they're not here.
Okay. Well, you've got a good setup there. All right, listen, Tim, just lay it out just plain for folks. And there's a ton of people that maybe haven't done this yet. If you pass away and you do not have a will, what happens? And I know it can vary. I suppose if you're married and you pass away and there's no will, well, your assets, I guess, automatically transfer over to your wife. But is it all that simple?
It's really not. One is that if most people who are married, I won't say maybe most people who are married, they're probably going to own their property as husband and wife, any assets, bank accounts, or whatever. So one spouse dies, and then the other spouse automatically gets that property. That's held jointly. So often, we see people that are coming in, and a spouse dies, and everything had been held jointly, and so then everything goes to the surviving spouse. No need for a will or no need to do probate. But if they have property they own separately, or let's say you have a married couple that owns, they have either bring property into the marriage or assets into the marriage separately, or they maintain property that separately. If one spouse dies, then the other spouse, then it doesn't automatically go to the surviving spouse. If there are children, then children would inherit also.
Yeah, and by the way, you talk about, you made me just think about this property, all right? So like, I know many couples who are married that have separate bank accounts. They just do, and they kind of pay, you pay for this, you pay for that, they don't argue over money, but it's just, they have separate bank accounts, okay? And they also have separate 401ks or, investment funds. So if a spouse dies and she has a Roth IRA somewhere in her name, maybe sometimes they ask you to list a benefactor, but I mean, is that the same issue with transferring that over?
You're going to name a beneficiary on that account.
Okay.
You should. If you don't have one, then it's going to go to whoever your heirs are, heirs at law, which would be maybe a spouse and children.
Okay.
So you want to make sure that, on assets that you own separately, like a bank account, make a beneficiary designation, like a payable on death or something on that sort of thing. That makes it easier for whoever's supposed to get that asset.
Okay, so yeah, I mean, that's where it maybe can get it doesn't get much better than that, and a lot of times it can get a lot worse. So even couples should go ahead and put together a will that specifies.
Yes. Right. Yeah, and especially for couples who worry, let's say one of the spouses, has a disability or maybe has Alzheimer's disease or whatever. And if the spouse who's not sick dies first, you want to make sure you have a plan in place so that the sick spouse, has that their assets can be managed and protected for that surviving spouse. So there's a lot of planning that can take place under those circumstances.
Do you have clients sometimes who come in that want to change their will? Like they've all of a sudden decided, I've had it with that grandson, he's out.
Every once in a while, we've seen that people will come in and they say, I've changed my mind about this, I've changed my mind about that. Yeah, that does happen.
Okay, and that's not a problem. You can get into change wills, and oftentimes I would imagine if you put together a will, and some people, I know people who put together their wills when they were in their 30s. They're just young and they're getting started. But I guess it's probably good to go back and review it, every 5 to 10 years?
Certainly, anytime your circumstances change or circumstances of one of the beneficiary of your estate plan changes, people get married, people get divorced, they go bankrupt, they have special needs children, they have all sorts of things that should persuade the person that is making the will that, I'm leaving money to my daughter, but she has a special needs child, so maybe I need to think about, should I leave something should I do a different type of estate plan if my daughter predeceases me? Those sorts of things. So you always have to kind of think ahead about that.
Have you ever, I'm just curious, maybe some interesting, will stories without naming names. I mean, I did a story a while back about a wealthy individual here in the Nashville area who you probably saw the story. I'm sure you've heard about it because it went national because it was interesting. He left several $1 million to his dog, Dixie. Okay.
Yeah.
He's a border collie, and it was to put into a conservatorship. And I don't know how that ultimately became resolved, but they took care of the dog. You can do that, right? I know you've got a bunch of cats. You have a bunch of cats. Could you leave and your lovely wife?
You can have a pet trust, is what they're called.
Really? All right.
Tennessee has a statute on pet trusts.
So you can set up a pet trust, and meaning that when you die, if maybe you don't have someone that you fear is around to care for the animal after you've passed and you love your animal, you could leave your assets and set up a trust and say this $100,000 is in a fund. My cat is to be taken care of.
Right. You can do that. Yeah.
I guess
it's sort of odd to think about that because you have a non-human person who's the beneficiary of a trust, which is that's not really what the common law.
Yeah, I know. It's different. I guess you would have to specify, who would be in charge of the monies and where the cat would go. And all those types of things. That would, just like any other will, you'd have to
leave it to, either a friend or a family member, or maybe, an organization or whatever that takes care of animals, and, that's what they do.
Yeah. This trust that this individual set up for his dog was such that the person taking care of it had access to the money from the sense of they could buy whatever was needed for the animal, and then they turn the receipts in. And they would get reimbursed. And ultimately, there's no way this dog's ever going to go through $5 million worth of kibble, okay? And I think ultimately it was also reduced down to let's just maintain what the animal needs. I don't know what happened to the rest of the money. There may have been other heirs there that made claim to it.
Yeah, that dog could live for a long, long time.
Yeah, I suppose so. So that's that. You can leave it for animals. I guess you can write in. And a lot of people who don't have family that they leave money to can leave money very directly to charitable organizations, libraries, hospitals, correct?
Right. And a lot of times if, like you go to a hospital or you go to the library and say, look, do you have a legacy plan? And a lot of them will help you set that up and say, look, you can, here's how it works, and they can even provide you documentation for how to do that.
All kinds of options.
If they don't, they should.
Yeah. Tim, listen, it's really good seeing you. I appreciate you weren't bored today. Was this okay? Did you have fun?
Oh, no, this was fine.
Okay.
Thanks.
I mean, I love having you on. And listen, I want you to, I probably won't see you again until at least after Thanksgiving, maybe even the New Year, depending on your schedule. Right. But have a great holiday and
you too.
Keep in touch and give my best to your lovely wife as well, all right?
I will. Thanks so much.
All right. Thanks much, Tim. And listen, we'll say goodbye to him. We'll take a break. When we come back, I'll have the contact information on how you can contact Tim and his staff at their office in Hendersonville if you want to pursue some of these issues right after this. Stay with us.